What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
Hello and welcome to the ABA Trust and Trade podcast series. This edition is called Behind the Author's Keyboard, and we are your hosts, Carter Simpson and Jack Martin. We're both partners practicing antitrust law at Hunton Andrews Kurth in Washington, D.C. Welcome, Jack.
Thank you, Carter. Welcome to you too, and welcome to everyone listening. So this month, Carter and I and two of our colleagues published an article in Antitrust Magazine, which examined recent developments in private merger challenges. Today, we're going to discuss a data-driven approach to identifying trends in private Section 7 litigation and what those trends may mean going forward.
Before we dive in, we first want to provide a quick primer on private Section 7 challenges and some of the other terms we're going to use today. Although we assume our listeners are either antitrust practitioners or in an industry affected by antitrust, we don't presume familiarity with the private challenges that we're talking about today, private challenges to an allegedly anti-competitive merger. Those causes of action are rooted in Section 7 of the Clayton Act, which prohibits acquisitions, the effect of which may substantially be to lessen competition or to tend to create a monopoly. Now, when the DOJ thinks a merger violates that statute, it's authorized to seek injunctive relief under Section 15 of the Clayton Act, and the FTC in turn proceeds under Section 13B of the FTC Act. But another provision of the Clayton Act, Section 16, grants private parties the right to seek an injunction for a violation of the antitrust laws, while Section 4 grants private parties the right to seek damages. It's the frequency of those private routes under Sections 4 and 16 that we're here to discuss today and that we've written our article about.
And before we do that, Carter, before we talk about any more specifics, tell us what is special under this statutory scheme about a private merger suit for damages under Section 4 or for injunctive relief under Section 16?
So, not much really. Sections 4 and 16 are just the catch-all private enforcement provisions that apply to the antitrust laws. Section 7 of the Clayton Act is one of those antitrust laws, just like the provisions of the Sherman Act and other statutes. No one in the antitrust bar thinks twice about a suit for damages or an injunction brought by a private plaintiff under the Sherman Act. And a private merger suit is essentially the same thing. It's authorized by the same statute, just applying another one of the antitrust laws. Now, Jack, you've been working in this space for over a decade, right?
I have. And it was about a year ago that I did a podcast on this subject when a case that I had worked on called Steves and Sons versus Geldwin generated a lot of interest because the district court ordered a divestiture several years after the merger at the behest of the private party plaintiff. And I was asked in that podcast if I thought there would be more of those cases. And my only answer really was anecdotal. I said, well, it just so happens that I worked on a second private merger challenge in the same year, which was a case called Food Lion versus DFA. And that case was settled before the court ordered any relief. And but it did survive a motion to dismiss, and there was an order from the court barring any material changes to the business while the case was pending, like a TRO, something that would preserve the court's ability to enter meaningful relief at the end of the case. And that was just an anecdote. So what we decided we needed a better answer. So what we did in our article is we took a deeper look and we looked up every private Section 7 challenge that's been filed since the turn of the century. And we'll talk in a minute about what we found, but even more important than what we found, we put the data out there. So anyone who wants to can take a look at the cases that we found, and there's a little summary of them in there, and they can draw their own conclusions. And if anyone wants to do that, Carter, how would they go about it?
So our article will include a link to the ABA website, which is where we put all the cases in a table with summaries and information about the type of plaintiff that brought suit, whether the government investigated, and whether the challenge was filed pre or post consummation. We also include citations to important decisions on the merits of the Section 7 claim. The table is going to show our methodology, including the databases we searched, the searches we ran on those databases, and a few secondary sources that we used as a backstop. We'll be updating a live version of that table on the Hunton website as more cases are filed in the coming years, and there will be a link to that as well. Now, at present, by my count, we've identified 76 private merger challenges. Jack, let's walk through a few of the conclusions we reached from analyzing that list.
So the most striking thing for me was that my anecdotal experience handling two of these cases in the last few years did not really seem to be unique. Now, certainly the Steves versus Jeldwin case got a lot of attention because there was a final order of divestiture, and we did not find any other final orders of divestiture in there. But we found a large number of examples of cases where you could deem the plaintiff to have achieved quote unquote success in filing a private merger challenge. And one case that kind of resonated with me was back in 2005. It was a Florida case, and the plaintiff challenged a consummated hospital merger, arguing that the merger gave the hospital market power that was sufficient to allow the hospital to force anti-competitive contracts onto health insurance plans. And the court rejected a statute of limitations defense on the ground that the statute began to run anew every time a new one of those contracts were signed. Now, we don't know the final resolution of the case. It disappears from the public record. But to me, that's just an example of great lawyering and a logical and really appropriate use of the private merger enforcement system to take a situation where there's a problem in the marketplace. It comes up at a time after the merger, but because of the conduct of the merged party, the plaintiff files a challenge, and then this challenge got past that initial limitations defense. One thing that we reflected on as we pulled together this table or this list of cases and found a number of instances of success was under the legislative scheme, it really shouldn't be a surprise that anyone is succeeding because of how important private enforcement was viewed to the merger system. So back in 1914, the year the Clayton Act was passed, there was, before passage of the act, there wasn't a merger statute, and the only enforcement of antitrust was done by the Department of Justice. It was viewed that state of affairs was not sufficient. So in the Clayton Act, you got A, a substantive merger law, B, you got a new government enforcement agency, the FTC, and C, you got the ability to have private enforcement. So to me, the fact that private enforcement was allowed by the very same statute that applied specifically to mergers says a lot about how important it is to the statutory scheme.
But I mean, Jack, despite that importance, you and I have seen firsthand, and now we've reviewed dozens of briefs and motions that characterize the government's decision not to challenge a merger as a quote, approval of that merger, as if the government somehow has the final word on the subject. Legally, we know that's just not the case. The confusion probably comes from Hart-Scott-Rodino, which is merely a notice statute. People sometimes equate the government's decision not to file a pre-merger challenge before the HSR waiting period expires with an implicit approval. This very issue came up in Steves, and DOJ filed amicus briefs and then appeared before the Fourth Circuit to express its view that the absence of a DOJ challenge doesn't necessarily equate to an approval. We also found a few decisions, pre-Steves of course, putting a stop to a Section 7 challenge simply because the court could not find any instance of a private plaintiff successfully obtaining a court-ordered divestiture. And many times courts don't even reach the question when plaintiffs can't overcome the threshold standing requirements that we know from cases like Brunswick and Cargill. So it's these known challenges that are what made our findings all the more compelling. It turns out that many plaintiffs have used Section 7 as a means of dealing with the problem of market power. We did notice an uptick of late. Only 19 private Section 7 challenges were filed between 2010 and 2015, versus 35 filed between 2015 and the present. 10 of those were filed since January 2020 alone, including one last month. But what was more surprising was the sheer number of challenges. and their success in either achieving something along the lines of an asset preservation or a hold separate order, or simply surviving to discovery. We've also identified commonalities among the more successful efforts, namely that they included vertically integrated defendants and that plaintiffs' theory of harm involved some form of foreclosure.
One common theme that we found was a combination of Section 7 and other claims in a way that makes perfect sense economically. So imagine an anti-competitive merger. It's an economic certainty that whoever gains market power through that merger is going to use it. And it may not be until the actual use that a plaintiff realizes it is suffering now as a natural result of a merger that already happened. That was essentially what the plaintiff was saying in the Florida hospital case that I mentioned. And we found a lot of other cases like that. We found a lot of cases more specifically where the plaintiff pleaded a Section 2 claim for monopolization, for example, or perhaps a Sherman Act Section 1 claim, and then added on that the Sherman Act violation was made possible by a consummated merger that had itself violated Section 7. So just as one example, we found a significant class action settlement against the mushroom industry. And the Section 7 aspect was a historical practice of purchasing mushroom farms and then reselling them with deed restrictions, which prohibited their future use as mushroom farms. And as I said, the class got a substantial settlement in that case.
So, Jack, given our findings, the big question that everyone's going to ask and that, is the real focus of our article is, where do we go from here?
So I think sort of implicit in that question is, will we see more of this or not? And I have two answers to that, one based on the numbers and one based on a very general overall trend. So as far as the numbers, it's hard for me to think of a reason why they would get smaller. I counted up 8 cases filed within the last 2 years that are still ongoing. And that's not a huge number, but just like the numbers you were citing, it's bigger than it has been in the past. You've got to expect that some of those cases will have merit, and the ones that do are going to combine the economic and legal theories that we've discussed, maybe for a successful outcome in the very end, or, as we've all seen in litigation, initial pretrial success and a good settlement. So that's what the numbers are showing. And then, I think everyone who watches this field is aware of something that's not merger specific at all, but the political and cultural background that we're in today. We kind of forget as antitrust practitioners that for the most part, the general public doesn't really care what we do or used to not care. Nowadays, you hear about big tech and antitrust almost every time you pick up the newspaper, and everyone who has a smartphone or a social media account has an opinion on that subject. And so we've really come full circle to where we were, roughly 100 years ago when Woodrow Wilson, antitrust was a huge part of his presidential platform, and that resulted in the Clayton Act of 1914. You have the White House just recently, within the last week, having issued an executive order telling the agencies to get more aggressive. You have a former presidential candidate, Amy Klobuchar, who wrote a book about antitrust. And the point is, for the first time in a long time, antitrust is a presidential level, high level, important topic in the political debate in the country and in the cultural milieu. What does that mean for private merger enforcement? I can't draw a straight line to show you exactly what, but it really, against the background of the numbers that we found, seems unlikely to mean less.
And at its core, our biggest takeaway from the data was that the unlikelihood of a private merger challenge can't be taken for granted anymore. Companies and the attorneys advising them on prospective transactions need to be aware of and account for the risk that a competitor or customer is going to decide that the implications of a merger acquisition in the marketplace warrant a private challenge, regardless of where the DOJ or FTC came down. Assigning value or probability to that risk means understanding the legal landscape and assessing all of the potential players. We hope our article and the accompanying data are able to further that dialogue and help parties, on both sides of the equation.
So thank you, Carter, and to the folks listening. We encourage you to learn more about this subject by picking up or logging into Antitrust Magazine, where you can find our article and the accompanying chart of all the cases. If you have any questions or comments, please reach out to us. And thank you very much for joining us today.
We hope you enjoyed this episode of Trust in Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.